NACDL is the association of the nation's criminal defense bar.
Morning, good afternoon. We're going to talk about bail in the state of Texas. So if you're not from Texas, this probably won't be that helpful to you. But if you are from Texas, hopefully it will be helpful, because what do our clients want more than anything? To get out. All right, so bail, we describe it as the new Jim Crow. It's the way they keep our clients in prison, and they can't get out because they don't have money. And so we're going to talk about the laws and the different things maybe you can do to help your client get out. Dix and Shlomeski, if you practice in Texas, you know they are the law gods. Even the Court of Criminal Appeals cites them. So arguably, the use of a bail schedule is contrary to the entire spirit of the bail process. And if Dix and Shlomeski say that, it probably means something. And these bail schedules, which we are continually told as defenders, well, that's what the schedule says. You know what? I don't care what your schedule says, because there's nothing in the statutes that talk about a specific amount. These are arbitrary amounts that judges make up to hurt our clients. And so we're going to fight that every step of the way. To begin with, Roth-Gary versus Gillespie County, it marks the initiation of the adversarial judicial proceeding that triggers Sixth Amendment protections. And if you don't know that case, that poor guy was in the Fredericksburg jail for months without counsel. And the United States Supreme Court said, no, this is an adversarial proceeding where you're entitled to counsel. And we have it codified in Code of Criminal Procedure 15.17. That is the hearing, the magistration. It marks the initial adversary judicial proceedings with the consequences of obligations to appoint counsel within a reasonable time after a request for assistance is made. So they can arrest you. That's fine, but you are entitled to counsel. And at that 1517 hearing, at the magistration, they will ask a client, do you want counsel? And or do you want appointed counsel? And most people, it's actually kind of sweet. They always say, I need some help. That's their code word for please appoint me a lawyer. I need some help. So at the bail hearing, a criminal defendant's appearance, there's a judicial officer. In Harris County, it's kind of unique, and it's not like small counties. We have full-time magistration 24/7. We have 2 judges working. Some do warrants and some do these bail hearings. And you're entitled to it, and you're entitled to representation, and you're entitled to be heard. If you had listened to the previous video from Sarah Wood talking about the initial bail lawsuit in Harris County, prior to a year or so ago in Harris County, a defendant was not allowed to speak at the hearing. In fact, they were said, don't say anything. So how can that be any sort of consideration of whether this person is entitled to some sort of bond if they're not allowed to speak? And that's what's great about having attorneys at these 1517 bail hearings is we can speak for our clients. In fact, many times, a lot of our time is spent trying to keep our clients from talking. We're like, no, I got it. I have a clipboard that I hold up and I whisper, shh, I've got this. So it's a really great process when you can have an attorney who has interviewed you and can talk to the judge about your particular circumstances of your client. So does the right to counsel attach in the Article 1517 hearing, even if a prosecutor is not aware or not involved? Yes. So you're entitled to that counsel. Do you need an indictment? No. How long can an indictment take? For those who practice, it can take months. They don't have to indict you within a certain amount of time. It's the arrest that triggers this sort of representation. And this is a chart which you can look on the screen that talks about the different areas when you're brought, when you're arrested. If you're not arrested by the sheriff's office, you're going to go through a municipality in Harris County. Sometimes by the time we see clients at a bail hearing in Harris County, they will already have been in custody more than 24 hours. And that is, to me, a lot of time. I've been told that's how long it takes. To me, it shouldn't take that long. You know, you arrest someone, you ought to bring them to the jail where they can be magistrated, where, you know, they can be booked, where they can be represented. But there's a huge delay. Okay, bail. That's the security given by the accused that he will appear in court. It includes a bail bond or a personal bond. In Texas, you always hear, can I get a PR bond, a personal recognizance bond? That doesn't exist in Texas. We do have a personal bond, so the judge actually sets an amount. And what he says is, I'll set the bail at $500, but I'm going to give you a personal bond so you don't have to pay it now. But if you don't show up, you will owe the money. So that's what a personal bond is. A money amount is set. So when you just basically swear, Code of Criminal Procedure 17.04, that, look, I promise I'm going to come to court. And then the judge can give you a personal bond. There is a release for Class C fine-only offenses. A magistrate may release a defendant without bond if it's a Class C. And we don't deal a lot of those in magistration. They have actually their own docket for that. So where do we get this bail? It goes all the way back to our U.S. Constitution, the 8th Amendment. I always think of it, you know, cruel and unusual punishment, but it's also excessive bail shall not be required. That's equally important. It's a traditional right to freedom. And for those of you who practice, you know how important it is to have your client out. It's hard to go to the jail and have a serious conversation with your client through glass or through a phone. You might have forgotten something and then you have to go out and get it. Your client might have some paperwork in his jail cell that he can't go back and get. So it's really important to have our clients out because they can better represent themselves to us and to the court if it shows, well, look, he's been on bond, he hasn't gotten in any trouble, he's working. It just makes everything easier and better and constitutional. All right. So in our Texas Constitution, which in many ways is sometimes can be stronger than the federal, all prisoners shall be bailable by sufficient sureties unless for capital offenses. And that's in our Texas Constitution, Article 1, Section 11 in the Code of Criminal Procedure. We also mirror the federal Constitution in Article 111C. For those of you who have not read the Texas Constitution, I'm disappointed. Because it's actually full of good things that we as attorneys in Texas should be advocating for. So the one thing they look at is a habitual offender. They may or may not be eligible for a personal bond. Typically in the bail hearings, they hold they are not. If you're accused of a non-capital felony while on bail for a prior indicted felony, you know, the DAs love that. Oh, judge, they're on bond for another felony. Okay. Accused of an offense involving a deadly weapon with a prior felony conviction, or accused of a violent or sexual offense while on supervision. I reject all that. I say you still argue for bond for your person no matter what. I think there's always a way to do it. You probably won't get it, but you know what? I'd do it anyway. Okay, the magistrate cannot deny bail on any of these. That's what the Constitution says. So when you're doing a bail hearing and the magistrate says, oh, I'm going to issue a no bond, I've actually told the judge under the Texas Constitution, you're not allowed to do that. And it's as if I was saying, wah, 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 because they still do it. But the Constitution says only a district judge can deny bail. So when I'm before a magistrate, they don't have that authority, but they do. And, these issues aren't appealable. Your client will always get another chance in district court or misdemeanor court to argue for bail, but it is true under the Constitution, a magistrate cannot do that. They can deny bail under Article 1, Section 11B, under these special family violence codes. There's a lot of constitutional amendments on these any sort of family violence and weapons sort of things. So the magistrate can deny bail. Again, it doesn't mean your client will never get bail, but the magistrate can deny it. If you violate an order of emergency protection issued by a judge, they can deny bail. Under the Code of Criminal Procedure, only a district judge can release on personal bond that litany of offenses. And this is something if you practice in the courts, you should be arguing for it. And I've talked at length about why it's important your client is out, but it really is important. There's some other things on charged with certain felonies, emergency protection order, sex offenses. It is controversial and it is an issue whether the magistrate can issue personal bond in that litany of cases. And it's based on the fact that the case is pending before the magistrate at that time. And in fact, the magistrate sort of acts as the district court, which is unique to large counties in Texas. Small counties, it's different, but the magistrate is acting as the district court. So when I said earlier that they can't deny bail because they're not a district judge, only when that helps me do I argue that. If it hurts me, I won't argue it. I'm just saying. And this is how this is the government code. It's in counties over 3.3 million. How many counties in Texas are over 3.3 million? One. So a lot of times the laws will be passed specific to a county. And so the magistrates do act on behalf of the district court. Okay, burden of proof to deny bail. It's not beyond a reasonable doubt, it's a substantial showing. So typically at these bail hearings, the DA will read off a dim summary. A dim summary is signed and verified by the police officer. So one thing I would recommend is watch and make sure the DA is not reading off anything but the dim summary. But since they only appear by video, you have to sort of try and watch what they're doing, like through the video. And I haven't quite made the objection yet, but I'd want to say, like, what are you reading? But it's not been quite the time yet. But there's tomorrow's a new day. All right, the rules of evidence do not apply in a magistration hearing. So you've got some hearsay, go for it. Because what are they reading in their dim summary? Hearsay. They got nobody there but some DA reading what some cop said that some witness said, right? I'm sure you learned that in law school, like triple hearsay, something. I'm kidding. All right. Setting bail. So setting the amount. There's 5 statutory considerations in 17.15. Reasonable assurance that the person will come back. You know, if they don't have a history of absconding, or even if it's only been 1 or 2 times, I'm sure they'll come back again, right? The amount cannot be oppressive. And that's one thing the bail lawsuit's been about. What's oppressive to many of our clients could be $50. I mean, $50 means, you know, whether they eat or not. So be very cognizant of what's oppressive to your client. The charge, the nature of the charge. If you look at this great video, these are all people who want to run onto the Astros field or some other sporting fields. Like, that's not serious. They act like it's serious because they send 10 cops running around the baseball field while the players just laugh. So anyway, you want to look at the nature of the charge. The ability to make bail is a statutory consideration. And the victim community concerns, so the safety of the victim in the community. But again, that's not the most important thing. It's 5 statutory considerations. So Harris County rules, they have the hearing officer, which shall consider employment history, residency, family affiliations, prior criminal record, previous court appearances, or their performance on previous court appearances, and any outstanding cases they might have. Then there's other considerations, the length of the sentence, the nature of the offense. Those are all considered, but none of them are more important than another. And I would say our client's ability to pay and to be free to fight their case is the most important thing. And the judge is supposed to consider each factor individually. And that's what's so important about having these bail hearings, because before the defendants were not allowed to speak at all. And now they do have someone who can speak for them. And it's, you can see a real difference in the sort of consideration in bail when someone advocates for someone versus when they're not even allowed to speak. So bond conditions, those are as multicultural, as multiple and as different as the judge can make up. I mean, as you all know, I'm sure you've all had some crazy bond conditions for your clients. So 17.151, incarcerated defendants must get affordable bond if the state is not ready for trial within 90 days for a felony, within 30 days for a Class A misdemeanor, and within 15 days. But you know who has to ask for that? You, the lawyer, have to ask for that. Don't let those times just go by. And it's not just the state saying, oh, I'm ready. I would say, well, are you ready? Like, you ready to go to trial today? The law says it's good enough if they say they're ready, but I would really press that. Do you have the DNA back? You got the autopsy report? Are you ready? Or are you just saying ready so my guy won't get an affordable bond? I'm not saying that happens. Okay, yeah, it does. All right. Conditioning a release on matters such as victim or community safety deprives the statute of any meaning and frustrates Article 17.151. It's clear intent. That's from the Court of Criminal Appeals. And so you really want to argue when it's constantly like, oh, we're fearful for the community or the victims are all upset. They might be upset about the offense, but number one, we don't know that our client was even involved. And number two, that's an emotional argument, and there has to be some clear factors like why they think this person is going to go out and commit more evidence. This is what I have to say about the law on bail. As an appellate attorney, I argue for appeal bond, but typically my clients are not qualify or not under the statute, aren't entitled to it. But what I would encourage all lawyers is to argue for bail, argue for it all the time, every chance you get. It builds client relations, it's client-centered, and it will make for a better representation of your client. Thank you.